All right, so picture this. You just bought your first condo, and you are thrilled because you got a fantastic deal on it, but then, just a few weeks later, bam, a violation notice shows up. And it comes with potential $5,000 bill for damage that was already there when you moved in. So let's get right into this wild story about a homeowner, her HOA, and one very, very expensive carport.
I mean, this is the big question, isn't it? It seems like it should be simple, but once you start mixing in real estate negotiations, all that confusing paperwork, and of course, HOA rules, well, the answer gets complicated, and it gets complicated fast, and this is the exact spot one new homeowner found herself in.
So let's meet our homeowner, Victoria Whitaker. From the second this thing went to a formal hearing, her position was, crystal clear. She's saying, look, I didn't cause this damage, and you, the HOA, can't prove I'm the one who has to fix it.
So, what are we talking about in terms of cost? Well, this is the number, $5,500. That's the estimated repair cost for the carport. And yeah, that is not a small amount of money. It's really the figure at the very heart of this whole fight.
Okay, so here's how this all went down. Ms. Whitaker closes on her new condo in the middle of June. Everything's great. Then, by mid-July, she gets this official notice from her homeowners association. It says her carport ceiling is damaged, and yep, she needs to fix it. The thing is, she knows for a fact that damage was there way before she ever got the keys.
Now, this timeline, this is where things get really interesting. You see, the HOA had actually cited the previous owners way back in May. Now, the sellers said they didn't do it, but they were clearly desperate to get the sale done. And then, on the exact same day Mrs. Whitaker closes on the property, the price suddenly drops by a whopping $20,000. And what happens a month later? That same violation notice shows up, but this time it has her name on it. And you gotta see this email from the sellers. It is so telling. On one hand, they're insisting they're innocent, right? We damaged nothing. But on the other hand, they are clearly under huge pressure to get this whole thing resolved before the sale goes through. That urgency, just get us a bill so we can make this go away, that becomes a really critical piece of this puzzle.
And then there's this text message. And honestly, this text kind of changes everything. It shows Ms. Whitaker's own realtor was in the middle of negotiating specifically about the carport issue. And the sellers, they were so eager to close the deal that they agreed to drop the price by that full 20 grand. This text message, it pretty much becomes the cornerstone of the HOA's entire case.
So you can totally see why Ms. Whitaker was confused, right? I mean, look at this. It's a tale of two documents. You've got the resale disclosure statement, which says, plain as day, are there any violations against this unit? No. But then you have the HOA's own compliance report, which points out, carport, damaged, seller responsibility. She's literally getting two completely different stories from the official paperwork.
So, faced with this mess, Ms. Whitaker didn't just roll over and pay it. Nope. She followed the process step by step. She shot off a written response, she asked for proof, and when the answers she got just weren't cutting it, she exercised her right and demanded a formal hearing with the HOA board.
But here's the thing about that hearing, at least from her perspective. She later testified that it didn't even feel like a real hearing. She felt like it was just a formality, that the board had already been talking with management for weeks, and they'd only heard one side of the story. Basically, she believed they had already made up their minds before she even walked into the room.
Okay, so now let's flip over to the HOA side of things. Their legal argument was actually pretty simple and direct. Their attorney basically said, look, it doesn't matter who actually caused the damage. What does matter is that Ms. Whitaker knew about it, or, reasonably should have known about it when she bought the place. This whole legal idea of actual or constructive knowledge, that's the absolute key to their entire case.
So it really all boils down to these two competing arguments, right? On one side, you've got Miss Whitaker. Her case is all about, I didn't do it, you didn't disclose it properly, the process was totally unfair, and your proof is basically just hearsay. But then you've got the HOA. Their argument is built on three simple pillars. You knew about it, you got a massive $20,000 discount because of it, and so you inherited the responsibility.
And on that point about evidence, Ms. Whitaker's defense pointed out what seems like a huge hole in the HOA's case. Their only proof was something called hearsay. What does that mean? Well, essentially, the entire violation was based on a single phone call from a neighbor. That's it. No written statement, no pictures, just a second-hand he said, she said account. And in legal terms, that's incredibly weak evidence. Okay, so we're in the administrative hearing now. There's been all this back and forth, all this testimony, and then the HOA's attorney just cuts through all of it and boils the entire case down to one single, incredibly sharp question. After getting her to admit she knew the carport was damaged and that the problem wasn't fixed, he asks this, and literally everything hinges on her answer.
And her answer, under oath, was just one word: correct. And in that one moment, she acknowledged it. She admitted that she understood she was buying a property that came with an unresolved problem.
And this brings us to a really, really important legal point here. The judge's job in this situation wasn't to figure out what was fair or who was morally in the right. Nope. Their job was much, much narrower. It was simply to decide, did the HOA follow the correct legal procedure? Did they give her proper notice? Did they offer her a hearing? This whole case, when you get right down to it, was about process, not necessarily about what we might think of as justice.
So, okay, after all of this, after hearing about the conflicting documents, the weak hearsay evidence, that massive $20,000 discount, and of course, that crucial one-word admission, what did the judge decide? Who was right?
Well, the judge laid out the key facts of the case very, very clearly. First, Ms. Whitaker was aware of the carport damage before she closed. Second, her realtor did negotiate that $20,000 price drop to account for that exact issue. Third, the association did provide her with a hearing. Fourth, the board made its decision after hearing the testimony. And finally, and this is crucial, no monetary penalties were handed out until after that whole hearing process was complete.
And so with all those facts laid out, the verdict was pretty decisive. The judge found that the association had, in fact, followed the correct legal process. Ms. Whitaker's petition was denied. From a purely legal standpoint, the HOA had checked all the necessary boxes.
And this quote, right from the judge's final decision, is really the ultimate takeaway here. It says, the association is not stopped from taking action against a new owner for violations that are obvious when they buy the place. I mean, that sets a powerful precedent, right? It basically means buying the property also meant buying the problem.
Which, of course, brings us all the way back to that first question we asked. If you buy a problem, does that make it your responsibility? Well, in the eyes of the law, and especially when there's an HOA involved, the answer seems to be a pretty clear yes. It's really a stark reminder for anyone out there buying a home. If you see a problem and you negotiate a discount for it, just know that you might be negotiating yourself right into taking full responsibility for fixing it.